the evidence that my client does, speak English or French. Here's proof by him or her taking the test. So at least that way, then because you can't just take somebody's word. Okay, the officer is not gonna accept that. They're gonna need a third party to validate whatever you're saying. So as long as you address all those issues and don't muddy the issue by bringing in more stuff that has not been addressed on the fairness letter. That's not,
Yeah,
you
that's
know,
a good point. Okay.
and it's a lot of people. What they try to do is they try to throw in the kitchen sink and everything, and they think that okay, let the officer decide. They're not going to do that. What they're going to do is that they were only going to address the issues that they have put on the fairness letter, and that's all. That's all you should be doing as well.
So they should try to be, let's say, a specific. They should have a proof, and for showing that proof, they need also to keep and store all the historical data of the activities, or even when it comes to the use of fund or other things, they need to have all those evidence. Because especially now that the processing times are so long, if you
Yeah.
don't have them, if you don't keep them, then later on, after a couple of years, if anyone is asking for those proof, you don't have them. And then sometimes I see that when they don't have, although that they are right, I mean, they had it, it was a proper source of fund, it was sale of a property, but when they didn't have a proof, they said, okay, we will ask someone to do it for us. And that was causing a misrepresentation because that was not a document from 6 years ago transaction or 4 years ago transaction.
Yeah.
So I would just say that recommend to keep everything organized over the time. If you have any meetings with the team, with anyone, business meetings or business visit, any of those ones, keep all those records organized. So whenever that is required or you are asked for, you can provide them.
Yeah. The
And
other comment I want to make here too is that make sure that go back and see what you actually submitted
mhm,
and make sure that the stuff that you're submitting now, why is there a difference, and try to explain it. If you know what I mean, like because if you
yeah,
submitted something 3 years ago that said, yes, I got this money from my dad, and now all of a sudden you're submitting something saying, well, no, it was as a result of me selling some property. You better be able to explain, why did you say what you said back
yeah.
then, and why are you changing your story now?
That's important. Yeah, that's really important, especially sometimes I think immigration professionals that are working with the clients to secure and somehow to assure they are adding more documents while the client is not aware. So it's important for everyone to keep those records. Plus, one important thing that you have mentioned about this document, and I think this is also along the way, is about the truthfulness and integrity that are the risk. And that's let's go where it show up most often. I think one of the places that integrity and trustfulness is showing is the business plan itself. And this is the heart of a business file. And you have reviewed, Claudius, a great many of this, what separates a credible business plan from one that quietly weaken a case and an application. And where do you think that this AI generated, for example, content go wrong? Because we were seeing before when clients were working with us, they had 5-page, 7-page business plan. Now they are coming with 100-page business plan, and they are super happy because they think this is the most comprehensive business plan. But can you tell us some of the risk for those AI generated files?
I think a lot of people are starting to depend too much on AI, and that's a significant downfall because officers can see it that it wasn't you or your representative that wrote this thing, because everything looks computerized. Okay, so and so you have to be very careful because the officer is going to say, how do I know that what this business plan is the correct one? It's just made up by AI. And make sure though that if you are going to use an AI business plan, generated business plan, that read it first yourselves, okay, and go through it and put yourself in the shoes of the immigration officer that's going to be looking at it. Does it make sense? Is it because I know especially but teaching at Queens, when I give assignments and people use AI to give their answers, some of the stuff AI makes up that doesn't there's no reality to it.
Yeah.
So don't just accept it just because you got AI to do a business plan. So it's very important that before you send it in, I think you need to sit down and put yourself in the shoes of an immigration officer looking at it,
And
and
read
then
it.
saying, yeah, and then saying, does this make sense? Like if you're building a company in Toronto, for instance, and it doesn't make sense that it should be in Toronto, but that's what AI, because you gave it those parameters, that's what it's going to show. And I would just sit down and read it. That's my best advice, I guess.
No, I think that's exactly good point. And I think I have mentioned this in our previous sessions, but we wanted to hear from your side because you were sitting also on the other side of the table, and I wanted to get the answer from you to how officers are seeing this. But from our side, also one of the things that I saw in business plans that was AI generated was about the boundary when they are giving a prompt to have that business plan. What are those boundary that they are giving to it? Sometimes if they are not stopping it from overclaiming, it's overclaiming everything. Like it's giving you a projection of $100 million after 2 years, which officers know that just, this is too good to be true. And these are something that it takes them to go deeper and deeper. So I would say make sure that is realistic. It makes sense when you are reading it. And the other point that I have seen from AI generated one are the market research data. They are not backed by the resources. So I think adding those resources of which website is showing those, those stats or, and double check, make sure that those links that even is providing, the AI is providing is accurate. That market research is I think, important one on the business plan for showing the validation of the proposed solution.
Yeah.
And this is not this is not just a topic now. There is something that is happening. IRCC AI strategy now flags altered documents, unusual bank statement patterns, and templated or AI generated business plan. And there is even a 2026 case that where IRCC's own AI got an applicant job duties wrong and a refusal rested on it. So the risk runs, I think, both ways for the officers and also for your clients, right? And this boundary that we are talking and the cautious, it's going to both ways when they are using AI. So let's check the room again. And this is the question. So if we can show the question. How often are your clients using AI to draft their business plans? Often, sometimes, rarely, and not sure. And let's say not clients, also you as your immigration professionals. Be honest, we have all seen it. So tap your answer while Claudius and I let this land. Yeah, I can see that what's coming in. And this tell us, let's just mention that this poll is telling us how much of a deep dive you want on AI and documents down the road for the next sessions. So let's share the results. 50% often, and 17% sometimes, rarely 11%, and not sure is 22%. That was surprising. I was expecting to see more of the often than 50%. But anyway, that is what we were expecting as well, right? Because we know that nowadays everyone is using AI for even daily basis for their routine work too. So for a client who insists on writing their own plan, how do you advise them? When is do it yourself genuinely fine? And when do you tell them to bring in a professional? I know that you already spoke about the cautious, where they have to be careful, at least reading it once, don't overclaim, don't write it too long. Too long, it doesn't mean that it's too good, and all of those ones. But do you have any additional points to bring here or no?
Again, I mean, make sure that your business plan addresses exactly what you are intending to do, and
Yeah.
that's it. You know, immigration officers are human beings, so you know if you try to BS them, they're they're going to see right through it. So I would, you know, stick to the facts. You know, don't worry that you know if it's a short one as compared to you know many pages. That doesn't mean that because you have many pages, it has any more credibility than a short one does.
Yeah,
Okay,
that's
as
not
long as you
impressive.
yeah, as long as you address all the issues that you want to address, that you want to make sure that it's uh, looked at by the officer, and you have the proof to back you up.
Yeah.
Okay, just making a comment in a business plan without any proof to back you up, it doesn't. It's just a comment. That's all it is. It doesn't mean anything.
Yeah, and talking about the business immigration, I just remember one point that I had a couple of clients that they were coming to us with the question, or they were asked from IRCC to provide clarification, or they were rejected because of this. It's a financial projection on the business plan. This is really important because I saw the AI generated ones is putting like, the great numbers, not only for the income, but also for the investment. Is saying that I will hire 15 people in the year one, and then I will spending $2 million. Can you prove that? Can you prove that you have that money? You can invest that money. You can hire those people, especially for PMP stream and business immigration streams, as you have to report the progress. And it doesn't mean that you have to hire 15 people exactly, but at least you have to show that you hire a few people. You cannot say that, or when you are saying, I will invest $2 million, at least you have to show that you invested $200,000, right?
Yeah,
So I
yeah.
think that's one of the things that they have to be careful. And now let's flip the desk around about the other roles that you have, because this is one thing to build the plan and another to see how an officer just, reads it. You sat on the other side of that desk for decades. And when an officer is assessing whether a business is genuine, what are the red flags that trigger a closer look? And we already cover this overclaiming or being too long, over explaining things, but how much can that extend that processing time? Or the other red flag, my specific question is that what is the impact of those red flag on the processing time and the review process?
Well, I mean, if it's been flagged for an issue, you know, that there's possibly misrepresentation or whatever, it's going to be going on the back burner for a while. It's not going to be, you know, a high priority for them to finalize the case. They may have to do some of their own background checks. So, you know, they may, if this is done by a visa officer, you know, they may send a message to the local immigration office to say, can you check and see, does this, you know, building exist, for instance, or, you know, things that they can't figure out from the visa point of view. So that's going to take some time. So for sure, you know, once the case is flagged,
Mhm.
it slows down. There's no two ways about it. And you know, unfortunately, in the old days when I was a visa officer, we used to interview everybody. So at that point, you know, when you interview somebody, you see them face to face. You know, what I was taught as a visa officer is that look at the person in the eye ask one question: will they make a good next door neighbor? If the answer is yes, accept them. Unless there's something drastic that you shouldn't accept them. Nowadays, they don't interview anybody. So so the fact is, it's what's on the paper that's going to make it or break it. But it has to be something on the paper that can be easily defended and proven. So as long as you have all your ducks in order, and that's part of your file, that file should progress quite well. But if there's something that's doesn't look right, it's going to be put on the back burner.
Okay, I see. And I think this genuineness is not only judged at approval, it's checked after as well, because as you have mentioned, they are not conducting interview at the processing level now, but roughly a quarter of business owner permit holders may now be selected for a post-approval compliance review.
Yep.
And that one is a site visit, it can be a document audit, it can be an interview afterwards. So to confirm the business is real and active. And the time that I believe it was in 2020, if I'm right, or maybe sooner, when the owner operator work permit was changed or was somehow unofficially
Eliminated. Yeah.
Yeah. The reason that I heard is that because they issued a year before or 2 years before that year, and they saw that out of 500 application that was submitted, they found out that 480 didn't have any business. So it was all because of the immigration purposes. So it was not useful for Canada. That's why that somehow they eliminated that one. That's the same case for the startup visa. I think after a couple of years, yes, of course, no one can guarantee that a startup would succeed. But then if they are running anything, any survey from their side, any report, and see that none of this startup exists, or even they spended money on that, or any time or effort, that's why that it's causing all this backlog and genuineness, and they are getting it harder on the other side of the table, which is after approval, right? Submitting some of the report. I think this is something that for business immigration, provincial nomination programs is already seen. That's why that they are giving them for a specific time work permit to let them prove that whatever that they claim on their business plan, it can be true. Or at least they made their best effort to achieve those ones. And now all these things, post-approval compliance is coming into the place because of the previous records and the history that shows, unfortunately, most of the cases, business cases specifically, were not helping Canada's just, revenue from job creation and all of those investment parts. It was mostly for getting a status in Canada.
Yeah. Well, a good example of that is when they eliminated the 50 points for having an LMIA under the express entry, because what they were doing is they were buying LMIAs and trying to get the extra points, and they didn't had no skills to do whatever that LMIA said they had to do, or they had any intention to work for that company. So, as a result of that, they eliminated that, which caused a lot of problems for a lot of people who, needed that extra 50 points or 200 points if it was senior executives. And, that's an example of what happens, so.
Yeah, absolutely right. And I think that enforcement is no longer abstract. Removals hits a record high in 2025, the most since 1950. I think that's the result of what everyone did in this ecosystem on the immigration. All these rejections that nowadays we are seeing, and so many of them are not fair or they are not correct, are the result of that previous history. So let's go to the last poll, which is okay. Which topic would help you most in a future session? Responding to refusal and appeals provincial entrepreneur streams, Sorry, I think it's responses, refusal, and appeals. Second one is provincial entrepreneurship streams. And third one is work permit, C11, and ICT. And the fourth one is building audit proof files. So we have four options here, a PMP streams, work permit, business work permit, and building audit proof files. Which one do you like?
Actually, there's only three
No, that's what
options.
I'm saying. I think there is a mistake. The first one is
Okay.
responding to refusal and appeal,
Okay.
and the second one is provincial entrepreneur streams. I think this one shapes where we go next, because which topic that you choose would help us just to shape the next ones, as I have mentioned. So let's see which one everyone is voting. I don't see the results. 25% responding to refusal and appeals. Oh, unfortunately, this one is merged with the PMP. So 50% work permit. Oh, that's interesting. And 25% building audit proof files. I thought that the first one would get the maximum, but especially now that is merge of two of the options. But thank you so much for participating. For sure, we will make sure that we will dedicate one session for the work permit, C11, ICT, and this type of the work. And as we promised in the beginning of this year, we will follow with the BC entrepreneurship, business immigration streams, and other provinces. Unfortunately, Ontario hasn't announced anything yet. That's why that we were not able to have Ontario session. But as soon as any new update is coming up, we will make sure that we will cover it in our next webinars. So we are hearing about like that 26 question letters that clients are receiving from IRCC, and more in-person interviews, as I have mentioned at that time. Later on the process, how should a consultant prepare a client who gets one of these practically, and what does that preparation look like? Yesterday, or it was a few days ago, we were chatting and you brought up an interesting point and an interesting regulation about accompanying IRCC or representative them on the port of entry. So if you can explain a little bit about that, that would be great for our audience.
Okay. Traditionally, it has been during an examination at a port of entry, the client does not have the right to counsel. In other words, and the Law Society had taken the IRCC to the federal court, and the federal court basically agreed with immigration to say that you do not have the right to counsel at examination. So a lot of people think that I'm going to take my client in and I'm going to do the talking and everything like this. That doesn't work. They'll kick you out. They sometimes, out of courtesy, they will allow you in during an examination, but you're only there just to observe. You're not allowed to basically talk for your client or present evidence on behalf of your client. It's between the client and the immigration officer that's doing the examination. So that's very important to understand that. And also, I'm just going to go back a little bit when you were talking about refusals and all this kind of stuff. A lot of people think that, I can appeal the refusal to the federal court, provided that I can, I have evidence that they made an error in law. Keep in mind, just because you may have received a positive decision by the federal court, it doesn't mean that your case has been approved. Okay, all it means is that all the federal court can do is basically order immigration to have another person look at the case. And as long as they addressed all the issues, it could result in the same decision, which means, in other words, a negative decision against your client. So, be prepared. Don't think that, I won the federal court, that means I'm going to win my case. It doesn't work that way. So I just wanted to stress that. about that. So
This is a great point. Thank you so much for the clarification because you are absolutely right that there are so many clients and people who think once the IRCC is settling on a case or they are winning the court, it means that they got approval, which is not. Sometimes you are saying the advertisement this way, but that doesn't mean that it's end of the story and it's a happy ending. It may we are seeing, especially nowadays, that IRCC is more willing to reject than accept, I would say, if it's right. But that's my opinion based on the stats that we are seeing. But I think now don't keep your hope 100% after winning a court process. Yeah, you're absolutely right.
yeah.
And thank you so much for bringing it up. I think that's a perfect place to open it up. For the audience to ask the question. If you have any question from Claudius, we received a couple of questions, Claudius, while I'm giving some time to the audience to write the questions. I have received a couple of those questions that I will start with those ones. One of them is if a consultant suspect an earlier file had an error, what should they do now proactively? If they
Has a decision been made on that earlier file?
No, I don't think so.
Okay.
It's still in process.
Yeah, as long as the decision hasn't been made, you can basically go in. You can either withdraw the file if you think, rather than have the officer make a decision, withdraw the file before a decision is made and then reapply. Okay, so you can do that. But or you can send a web form saying I need to change this whatever you think there's an error that was submitted, and with an explanation as to why it was submitted, and there was no intent to mislead in any way, shape, or form, and
Oh.
That can work.
Okay, that's great point. So don't worry if it's something that it was not intentional. You can submit a web form. As someone else earlier asked, you can withdraw that case and resubmit it if it's something serious. But if it's a small error, you can submit a web form, provide the something that is true. I mean, the evidence that is true, and you think that that's needed to be submitted in the beginning, or if one name is typed by mistake, all of those ones, I think that can be resolved. The next question is, can we submit C11 applications for our clients that are stuck in the backlog of a startup visa?
Well, I mean, if you have enough evidence to be able to prove that this is a new C11 type case, then I don't, it's a different application. So I don't see a reason why you cannot.
Yeah, because they haven't received any update regarding the startup visa, but so nothing is stopping them from not only applying for the C11, I think even also for any other streams.
Yeah, you can have multiple applications, and you can do
But
express
once they
entry.
receive the confirmation somehow, which means that they are processed. That's the time that I think they cannot have two applications at the same time. Am I right on this?
Well, yeah. I mean, you're gonna have to decide, I guess, at that point, because they're working on that case.
They have to withdraw one of them at that point. But like now, a startup visa that even they don't have a file number or they haven't even received the AOR, they can still submit another. Okay. Whether it's for, especially I think for C11 specifically, is helping with the startup visa, because it's showing that the reason that you wanted to come to Canada with work permit and now you're applying for C11, it means you are serious about the work that you want to do. And also you are showing that I'm bringing sooner that investment. I'm coming to Canada to build that business that I applied under a startup visa. I think it can help in your favor as well. Sometimes it depends. If it's completely different business, I think doesn't make sense. The other Yeah,
You,
make
you
sure
you
that
have
you're
to be careful though. You have to be careful that, if you all of a sudden invest in Canada, but the question is, where did the funds come from? You have to be able to make sure that you're able to explain that. I both in the C11 application, but also on the startup visa application. So that doesn't exempt you from just because you've invested in Canada to say, okay, now I'm clear and everything is okay. It doesn't work that way. So
And I would say if a startup visa needs some innovation, right? If that one is a different business plan, then you decide to come and open a pharmacy through C11, that contradicts with the previous application. So I would say just keep it if it's the same business that you submitted under a startup visa, it's going to be helpful. But if it's completely different, or you are putting something that doesn't align, especially the resume part, doesn't align with what you have built and submitted for the startup visa, it's bringing more red flag for you. So be careful
be
that
be
everything is aligned.
consistent. Be consistent.
Be
That's my
consistent. Yeah, that's a perfect one. Yeah.
yeah.
Next question is, we recently had a case whether we submitted withdrawal application in January 26 and received PFL in March 26. Can something like this be disputed?
Well, I mean, the fact that they're giving a procedural fairness letter, that means that they've already were in the process of making a final decision on the case.
Mhm.
Okay, so when you withdraw something, it's usually like you have to be careful when you submit a withdrawal and at what process the application is in. If it's almost close to the end, they're not gonna accept your withdrawal because they've already made a decision or they're in the process of making a decision. So you have to be careful there as to when you submitted your withdrawal. Like if it's, you submitted the application and then you realize there's something wrong, so you didn't want to go forward anymore and you withdrew it, that's one thing. But if it's already been in the hopper and it's been processed, they've started the background checks, they've started, they took the money and everything like this, that becomes problematic when you try to withdraw, because then it sort of implies that you're trying to hide something.
Yeah, that makes sense. And if a cancellation in mass happens, is there any legal recourse against such cancellation? Can they do anything?
Well, I'm sure the Law Society or somebody that can do federal court appeals, is going to do a mass appeal to the federal court to decide whether it's, does C11 or C12, sorry, overrule, their Charter of Rights, or, I'm sure there's going to be an argument on the Charter of Rights that you don't have the right to withdraw something that you've already asked me to apply for. So the courts are going to rule. That's why I said, with Bill C12, there's going to be a lot of challenges that are going to be going through in the courts. And, it may even go up to the Supreme Court of Canada before a final decision is made. So, but until a final decision is made, they're going to proceed with, with their own decisions that they made, because they haven't been ordered not to.
Okay, perfect. Thank you for the answering this question. And last one that we can take is, I would like to see that officer consider the employer's interest, and for that matter, the country's interest in keeping an employee working who is waiting for an LMIA approval. The interruption is significant for an employer waiting for the paperwork to engage an employee who was already working for the company and the work permit expire. So we hope the same thing happens. But
I'm assuming you're talking about while waiting for an LMIA to be approved. Is that
yeah, I think it's when sometimes the employer is working with the employee under LMIA, but the LMIA is expire, or just somehow they apply for the LMIA, the answer is not there yet. They are saying there is an interruption between that time that they are waiting And doesn't make sense that they are waiting, they have to wait for that paperwork to engage the employee again. Since that employee used to work, this is an interruption for the business, right? So, but I didn't get exactly what the question is. I understand, I would like to see, but I don't know if there is a question here. We would like to see the same things. We are with you and we agree with you that just, this is an interruption for the business and it doesn't make sense sometimes.
But I think you have to understand, though, the reason for the LMIA process. It's not for the employer to hire a foreign worker. It's for the employer to be able to prove to the government that they cannot find a qualified Canadian. And that's a very, the distinction has to be made. And employers think that, well, no, I just want to hire, Joe Smith, even though, he's a foreign national. Well, that doesn't work that way, and the reason for the LMIA is for the employer to be able to prove that they've done their due diligence and they cannot find a qualified Canadian. Just because you have a foreign national working for you, that doesn't just allow you just to
That is
carte
your
blanche
best to
to-
find a Canadian. Yeah.
Yeah.
Exactly.
So.
Exactly. No, that's true. And I think that take us, let me see if we receive any new question here. No. So I think that would take us to the end of session today. I wanted to mention before we go a few points for the next session. First of all, Claudia, thank you so much. That was really valuable. And I think everyone here walks away with some important, just, insight. If there is one thread through everything today is this. I think in 2026, approval is a start of the risk, not the end of it. And the consultant diligence is what protects the client and the practitioner alike. And as Claudia's mentioned, be consistent in every file, in every application that you are submitting for that client. A few quick closing notes also here for the questions that you didn't have a chance to write it down or we didn't have time to go through. We will send the responses by email after the session. You will receive anyone that registered for this event, but they were not able to attend. You will receive recording after the meeting. You also will receive a survey from us. It's a short survey that will help us to shape and make the webinar series better. So please take a few seconds and complete those surveys that we are sending to you. And one timely reminder for those of you with 2025 Startup Visa certificate holders, that permanent residence deadline is June 30th, just days away. So please flag those files this week that you haven't submitted the PR application yet. And one happy note before we go, after hosting this series since the beginning, which was early 2025, I'm going to be handing the host chair to my colleague Sajjad Bahrami, and many of you already know him. I'm not going anywhere. I'm still shaping every session behind the scenes, but starting next month, Sajjad is your host and he knows this audience, these files inside out. So the gateway is in excellent hands. And our next event is Tuesday, July 28th at 11 a.m. EST. You will receive email from us with more information about the topic and our guest speaker for the next month. So Sajjad, the floor is yours next month. And to all of you, thank you again for Claudia's and thank you for being part of this, everyone. This has been a Business Immigration Gateway. We will see you in July. Thank you and have a wonderful day. Thank you so much.
All the best.
Thank you, you too.